Actually, she filmed it while I was talking too much.
Well, we'll try to keep the volume down.
Right.
I'm gonna scoot to another room to see, just right next to me, and see if this echo goes away. I'm just gonna move the laptop with me.
Okay.
All right. Before we go on the records, look like everybody's here.
I've got one more witness I need to call and see if he's going to get online.
All right, go ahead.
Preston logging back in right now.
Okay, Judge, my witness says he's online, but I don't see him yet. Is there a witness room you put him in?
Do what?
Is there a witness room that you have a witness in?
No, I've only got 3 participants right now.
Yeah, Preston's gonna have to come back in. He had an echo sound.
Okay, well, I don't know who your witness is, but they haven't.
He's getting back in now.
Okay.
They haven't come online.
All right.
Just so everybody knows, court reporter's here with me.
He's trying to log in. He said it's going to be a couple of minutes because the whole thing went down when he moved the computer to the other room.
Okay.
Do you have any wind damage?
Yeah, a few rounds. Nothing big.
Preston be back in at about 60 seconds. He got to the email. He had to start all over again. Robert, do you have to bring Preston back in?
Hold on. It's just taking a while. I just need time. I just need a little time.
Okay. You need a little time.
Okay, I'm coming back in. God, I ain't being rushed. All right. Can you hear me better now?
Yeah, that's better.
All right. Looks like we got everybody. Everybody ready?
Well, Judge, my brother Perry's on the road and he's in a big rainstorm and he don't have any internet. He's in between Louisiana and Mississippi right now on the road, carrying hazmat. So he's still trying.
Okay. Is he a witness to your motion to remove executor?
Yes, Perry Mason is the main witness, yes.
Okay. Well, I hope he's able to get in.
I just I'm hoping he is too.
Your motion's first. Hang on a second. Let's go on the record. Ready? All right. Let's go on the record in cause number CCL 1-PR 2021-0157. Carlock Estate. Here today on several motions. One, motion to remove executor in a pro se capacity by James Mason. The others brought by Mr. Rayfuse show cause for removal of individuals from the state property. Mr. Mason, are you ready to go forward?
Yes, sir.
Or James Mason, you ready?
Yes, sir. Yes, sir.
Mr. Rayfuse? Mr. Rayfuse, you're on mute.
Sorry, Your Honor.
All right, you ready to go forward?
Has the service been completed on the motion to remove?
I don't know.
Last I looked, it hadn't been completed, and I talked to the resident agent yesterday and she hadn't been served.
Mr. Mason, did you serve the resident agent with your motion?
I have no way of contact. My brother Perry and know about this, but the resident agent, I have no way of contacting her. So the deal is, we'll start is we got police reports, Your Honor.
So the short answer is no.
Oh, sir, I sure didn't. I gave everything to the attorney and whatever the resident agent needed, I wasn't aware of.
Well, Mr. Mason, you have stated several times in this court that you're a paralegal and that you know the process. To remove an executor, you have to have them personally served with the motion. The resident agent would be the one that you would have to serve.
And that is, okay, I got that paperwork of resident agents, and we was in Judge Hughes' court with this, and Judge Hughes, in his court, he had told the resident agent, if you wanted to proceed with this, to bring a title that has Preston Carlock name on it. He proceeded with the court, went to the Wednesday, the 5th, and they came in with a contract, somebody trying to buy the house, and he dismissed the case. So this case was dismissed. Judge Hughes dismissed this case in his court as she was making his resident agency, because he couldn't comply with the court's ruling, bring the title with his name on it. And so therefore, I didn't think after that's dismissal, yeah, I didn't feel it was relevant.
Mr. Mason, that wasn't the question I asked. The question I asked was, did you serve the resident agent with the motion to remove the executor? Simple question,
No.
yes or no?
No, sir, I did not, because at the last hearing, I felt that dismissal was done, and I didn't see the paperwork I have showing the resident agency. I wasn't involved in the court proceedings on that, because I denied that, period. But so, no, sir, I didn't, and I guess I don't have any excuse.
All right, that motion will not be heard until service is effectuated.
I could email her this. I mean, I didn't know that was gonna, you mean tell me I can't proceed? I mean, this is
Yes,
relevant.
that's exactly what I'm telling you, is you cannot proceed on your motion to remove the executor until the personal representative is served with the motion. That's exactly what I'm saying. So
Okay, so-
we will
so-
hear that motion once you get service. That matter will
Well,
have.
the only contact I have, Your Honor, is through their attorney. I don't have her, nothing, I don't even have her phone number, sir.
I believe it's in the court filings, is it not, Mr. Rayfuse?
Yes, we did an appointment of resident agent with her address on it.
It's not in the resident agent.
It's in the court filings, public record, you can look it up.
Court filing, public record, okay, then I don't have it in my, I got everything that the guaranteed title had, all the documentation that went in, the registered agency here, right here, March 25th, 2023. They don't have the resident agent, Janelle Thibodeau. Only thing they have in here pertaining to her is her email.
That doesn't have anything to do with it. She has filed her as a resident agent and listed her address.
There's no address on here, sir, just an email, sir. Robert Refuse address is on here. Everybody else is an email. I don't have her address nor a phone number on this document. This comes from the guaranteed title, sir. And this is their copy. There's no Janelle Thibodeau on here with the address other than Janelle Thibodeau, filing manager, Janelle Thibodeau, 1959 yahoo.com. That's all I have on this document.
I'm looking at it and it was filed March the 28th, 2023.
And this one is March 25th, 2023.
Mr. Mason, you have to, if you're going to represent yourself, we've had this discussion before.
Yes, sir. Yes, sir. Yes, sir. I'm sorry. Well, I'll email it to her, sir,
That's fine.
today. You say I had to present it to her, sir. How else can I?
I did
present
not.
it?
I never said you had to present it to her. I said she had to be served with the motion. There's a difference.
Okay, so I have to make a subpoena toward her. Is that what you're saying, sir?
I'm not telling you what to do, Mr. Mason. You are
Well,
representing yourself. You're presumed to know.
Yes, sir. I know. I look at, yeah, I have to serve her. Okay, I'm sorry, sir. I'll send that out. And I guess I'm done with the hearing today.
Well, you're done with that portion of it. Yes. We still have Mr. Rayfuse's.
All right.
Mr. Rayfuse, are you ready to proceed on your motions?
I am ready, Your Honor.
We're right ahead.
The movement would call Preston Carlock or Moses Preston Carlock III.
Mr. Carlock, can you raise your right hand for me? You solemnly swear or affirm testimony you give in this matter be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Go right ahead, Mr. Rayfuse.
State your name.
Yeah, Moses Preston Carlock III.
And you were appointed by the court as the executor of your mother's estate back in November of 2022.
That is correct.
After you were appointed, did you contact my office and request that I prepare a letter to Perry Mason and all other occupants at the address of 1704 North Beverly?
Yes, sir, I did.
And is that the final letter Movements Exhibit 1, which you looked at over the weekend?
Yes, it is.
And in that letter, this included a 30-day notice of termination of lease.
Yes, it did.
I move to Movements Exhibit 1, the letter to Mr. Perry Mason and all other occupants at 1704 North Beverly.
Any objection to one?
I have some questions, sir.
No, I'm asking if there's an objection.
For this affidavit, yes, because there's
No,
an objection.
not an affidavit. It was a letter that was offered as Exhibit 1. Do you have a copy of it?
Yes, sir, I have a copy, and I have objected to this because Perry Mason never received this. He's on the roll, been on the roll, and there's no certified letter saying that he's received his letter himself.
I'm asking for a legal objection. Is there a legal objection?
No, sir, not to the affidavit in fact.
Exhibit 1, the letter, not an affidavit, the letter will be admitted.
Mr. Carlock, prior to this letter being issued, did you have some kind of an oral agreement with Perry Mason concerning the occupancy of that property?
Yes, I did.
What was that agreement?
Mr. Perry Mason had some issues with his credit. When we were discussing on what to do with the house, he did not want to sell it. He wanted to purchase it himself, which would have been great because all the other siblings, which are on the will for the home, would have received compensation after his purchase. He needed some time. I gave Mr. Mason a full year to get his credit together or to a certain score that he needed in order to purchase the home. A year later, he had not done that. He had not obtained the appropriate credit score or the ability to purchase the home. At that time is when we went in proceedings on going forward with selling the house, since he was not able to accomplish that task.
In the meantime, did taxes become due on that property?
Yes, they did. He paid the initial taxes, which were the first year after the passing of our mother. The second year, he has not paid the taxes on that home.
Did he pay any rent during that year that he stayed in the home?
No, he has not paid any rent at all.
Do you know approximately how much the taxes are at this time?
I think the last check we checked on, it was approximately 31 to 32,000 a year.
I mean, 100?
Excuse me, I'm sorry. 31 to 3,200 a year for the taxes.
And do penalty and interest get added every month that it's not paid?
Yes, they do.
Yeah.
At this time, I'll pass the witness.
Okay.
Since you're representing yourself, I'll allow you to question the witness. Go ahead.
Okay. Your Honor, as far as the probate code is concerned, this person, Perry Mason, is a beneficiary, and under probate code 401.006, the legislation that added this law said it is independent executor are responsible and must carry out of all his duties and take care of the descendant's property as a prudent person would. And also states that any mismanagement of property betrays the trust of the beneficiary.
Mr. Mason, hang on, I got this. Okay. Mr. Mason, you have an opportunity to question the witness that you're about to forfeit. You're making argument with the removal of executor. Okay. That motion will be heard later once you effectuate service on the personal representative. Like I said a while ago, I'll give you one last opportunity to question this witness. Otherwise, I will say that you have forfeited your opportunity and I will move on.
I'll question this witness. Mr. Carlock.
Yes.
As the executor of the estate, sir, you had authorized the sale of this property for $51,000 to a person, Larry D. Lawrence. Is that correct, sir?
Yes, we have found a buyer for the home.
And this estate is actually worth $170,000, close to it, give or take. And you're willing to sell that property at $51,000. And I still haven't heard from the court as far as my is what I have in the state.
I'm going to object to the witness testifying as to the value of the property, Your Honor. That has not been established.
Okay, so this agreement that you have, sir, is agreeing what you plan to do once you remove Perry Mason from this property. Is that correct?
The house is going to be sold once Mr. Mason is correct.
So are you as executor violating the this Perry is a beneficiary, and he's living in the house, trying to get the house together. So you're going to deny him as an heir to that house, don't these wills state, and even the
Your Honor,
tax
I'm going
people,
to object to the question. He's crossing the line into the motion, which will not be heard today.
okay.
Objection
On the
sustained.
tax form I have here, there's an amount due. Perry Mason paid 2021 and 2020. Now they got amount due for 2022 for $3,212. And the account shows here owner, Michael Mason, Janelle Mason, Perry Mason, Sandra Seaton, and you're not even on here for the owner. Did you know that? Did I submit this?
Yeah,
Sir.
the court, I already contacted the court, and the way it is, the court said that there's a second page. There were too many names to show on the original page. And if you had access to the second page of that document, my name is on there.
I just received this document today.
Yeah, there's a second page to it.
Okay, all right.
I seen the same thing.
Okay, so sir, these are the heirs. Are you aware of the executor protocol for the heirs? I mean, you know, you're trying to sell a property that you only 1/5 the owner. Is that correct?
The property was split into between 5 different individuals. That is correct. Yes.
Okay, so if Perry Mason, I can't get him on here for some reason, is the other 5th owner, and he now occupies a house. So are you going against the fiduciary rules of denying the heir his fiduciary right? I mean, seriously, he's the heir to this property. How do you get the authority? How do you get the authority? How do you get the
Objection, Your
authority?
Honor. He's not allowing the witness to answer his question. If I understood his question.
Yeah, so once the house is sold as the sole executor, which I am, once the house is sold, the proceeds will be split 1/5 between the 5, which Mr. Perry Mason will receive compensation for his 5th as being a 5th owner of the home. He will not be denied that.
Okay. As it state, is it true that in the will of Teresa Carlock Davis, she said, I authorize and empower my co-executives to sell, dispose of, delivery, convey any portion of my real estate, real, personal, or public or private sale for any price for the purpose of paying any debts or legacies. You're violating the will of my mother, Teresa Carlock Davis, in the
Objection, Your Honor. He's again crossing the line into the motion to remove, which is not going to be heard today.
Sustained.
Okay. Therefore, I express one more question. Can you prove to me that Perry Mason received any letters or anything certified with his name on it personally, even from the constable? Can you prove any of that documentation?
My documentation was submitted through my attorney. That information at that point was sent to that address. If Perry, whatever, received it, if he tangibly received it, that is not my responsibility to prove that.
Well, he didn't receive no certification. Anytime you see, they had to be certified, sir.
Yes, I can tell you for sure, 100%, every single document was certified.
Okay, and then the return certificate, do you have his signature on that return certificate?
You would have to talk to my attorney about that.
Well, that certificate comes to you. The certified letter, you came from you. The return certificate would come back. I guess I'm wrong, Your Honor. I must be not educated enough to work how certified mail work. From my understanding,
my certified mail was sent from my attorney's office.
Oh, so Mr. Refuge, did you receive a certified copy? Can I actually return to this, Your Honor? Because I want to know where the certified copy is of Perry Mason's signature. How can you make an accusation? How can you even submit documents that's not even verified by the person that's living in the house?
Mr. Mason, I'm not sure I follow you. You've got a question. You have an opportunity to question the witness.
Yes, sir. I asked the question, is there any return certified on the certified letter showing that Preston Perry Mason received a certified letter, signed for the certified letter? That's all I'm asking, sir.
All the documentation was submitted through my attorney's office.
So I guess the attorney would have that answer, sir. Your Honor.
This is your opportunity to question the witness, Mr. Mason.
Well, he's, okay, so if you didn't, your attorney did the certified letter, did you personally do the certified letter? Let me find documentation showing you personally did the certified letter. If I can find it. On, so you telling me that all the certified letters that came out came from your attorney? With your signature on the certified letter claiming that you yourself sent the certified letter and you say the return certificate went to your attorney, correct?
All documentation was certified in front of a military attorney, which I'm at a military base, and that information was certified and sent to my attorney. All certified letters were certified by appropriate legal personnel and sent through my attorney's office for further
So
process.
can you produce a certified receipt of the certified letter being sent or given to or to Perry Mason?
I've already answered your question. All certified letters were certified by a military legal attorney. Information was then pushed to my attorney's office for further process.
Okay, did you orchestrate for your resident agent to get the locks changed to gain entry into the house of Perry Mason where he was living? Did you authorize her to gain entry? Then I got a police report. Property has been taken from there, a TV, a gun, some jewelry, the car and vehicle was taken from there.
Objection, Your
Sir,
Honor. The
did you authorize that? Yes or
party
no?
is asking questions and testifying at the same time.
You need to ask a question.
You authorize Janelle Thibodeau to go into Perry Mason house and steal property out of there.
So first of
Objection,
all,
that's a compound question.
Let's get,
Did you authorize Janelle Thibodeau to get
Mr.
into?
Mason, you don't talk over me.
Yes, sir. I'm sorry, sir. Yeah, I'm sorry. I'm sorry. We meet you, sir.
Mr. Carlock, I believe the question is, in your capacity as independent executor, did you authorize an individual to collect property of the estate?
so as far as going to the property to gain access as a 1/5 owner, let me just clearly state, Mr. Mason, that that house does not belong to Mr. Perry Mason. It belongs to all 5 names. So there's 5 owners of the house. So all 5 of those personnel own that house. We had indications that that house had been abandoned because number one, there's a neighbor in the rear that contacted my other sister, said nobody's been in that house for over 2 months. To also verify that, we contacted the utility company who said that that water and electricity had been turned off for over 2 months. So at that point, we were looking at an abandoned home. We have not heard from Mr. Mason. Our attorney has made attempts to contact Mr. Perry Mason and to get a response from him that has went blank negative. So we're looking at an abandoned home at this point, which we are 1/5 owners of. So yes, in my absence, Miss Janelle Thibodeau did gain access to the home, and the results of that was confirming the abandonment of that home after she went in.
So therefore, you're telling me that she had the right to remove a TV set that was actually mounted, and it had to take time for someone to unmount it because my brother had to, he told me. So, and then went into his bedroom and took a gun and jewelry, silver coins. So you authorized all of that, right? And then the 2 vehicles that was on the property, you authorized them too as well?
No authorization was given for anything to be removed. If you're talking about the abandoned vehicles, we cannot, at this point, we're preparing to sell the home since we have not heard from Mr. Mason. The utilities have been turned off, the water has been turned off. And when you went in the home was severely damaged. There was rat droppings. Plumbing was pulled out of the walls. There was an unauthorized vehicle in the garage, which after further investigation was being looked for from a bank that's looking for that car, which was practically stolen. So the other vehicles are abandoned. They did not run. So we were trying to prepare to sell the home.
So that was your right to go into a private home that was
Not a
occupied
private
by.
home. I'm partial owner.
That's right, but his property was in that home, so he's missing property. So you
I
authorized-
have no knowledge of his missing property.
We got a, Yana, I'd like to submit evidence, police report, Wichita Falls, Texas, of reported for the vehicles being taken off that property. We found the vehicles on another man's property.
I'm going to
we-
object to any exhibits being admitted at this point. It's a Zoom hearing and there was a deadline to submit exhibits, which was not met.
Okay, so
What's-
Your Honor, so you telling me that you did not authorize, you authorized her to go in the house. So how did she obtain entry into the house that had the Perry Mason, his wife had keys to it? She had a locksmith come out there?
She's partial owner.
Did she have a locksmith come out there? Yes or no?
She's partial owner. She can gain access to that home as partial owner of the home. And as I stated, the home was in an abandoned condition. Utilities have been turned off for over 2 months. Neighbors saying they haven't seen anybody come and go. We have a responsibility to prepare that home to be sold after it's been abandoned.
Well, sir, that house was not abandoned. Yeah, I did never contact Perry Mason to find out where he was. He'd been on the road.
Again, as I said, my attorney has made several attempts and opened the door of communication for Mr. Perry Mason, which Perry Mason has not taken advantage of that opportunity to respond.
Only if okay, so the only communication that Perry Mason received from your attorney came through the mail, correct? Through the US Post Office, correct, right?
Again,
correct.
Mr.
Yes or no?
Mason has not.
Perry did not receive that information, so how can you?
Mr. Mason, you are not going to talk over myself or the witness. You are going to ask questions. And Mr. Carlock, if the answer calls for yes or no, answer yes or no.
Roger.
Mr. Mason, this is one last chance to question this witness. I've had enough of this back and forth. I am not going to deal with family disputes. Mr. Carlock is the independent executor of the estate. He has a duty to the estate to take control of estate assets. Now, Mr. Mason, as much as you like to say you are a paralegal, I do not find that you have much knowledge in the probate arena. It is his responsibility to take control of the estate assets.
Okay, Your Honor, that's true, but the estate assets right now, and my mother stated in her will that if it's to pay for the purpose of paying any debts or legacies. So they're selling a house for personal pleasure or preferences.
No, you're not reading that correctly, sir.
It's okay, sir. It says, I authorize and empower my co-executives to sell, dispose of, deliver, and convey any portion of my estate, real or personal, at public or private sale for any price, on any terms, and in any manner that may seem to him best for the purpose of paying any of my debts
Or
above legacies. Above legacies.
you know what legacies mean, sir?
Yeah, that's talking about the heirs.
Yes.
Okay, so it's also in rule, okay, I can't do that. Okay, Your Honor, I do have police reports for the illegal entry and then for the step of property. I guess I'm gonna have to put that subpoena in for another date, because I'm not gonna be able to I'm sorry.
Right now, it's a show cause order to have Mr. Perry Mason removed from the residence if he still is in the residence. That's it.
Well,
That's all we're hearing today.
okay, Perry has been on the road, Your Honor, and he's been driving so he's not in the residence right now, he's on the road. So
That's not what I meant. And
okay.
I'm sorry that he can't be available for this hearing. He's had notice of this hearing.
He
Now-
has not received
Now the
notice.
next, hang on. Now the next part is you are prohibited by law from representing any individual in this matter except for yourself. Do you understand that?
Can you say that again, sir?
You are prohibited by law from representing any other person in this except for yourself.
Okay, I understand that. I was just.
If you
speaking
purport to
on behalf-
represent Perry Mason, you are actually committing an offense.
No, I'm not. I was just asking you, sir.
And you should
said-
know that because you sign your things paralegal.
Yes, sir. Okay, no problem.
So with that understanding, let's move forward. You have one last opportunity to question this witness. Do you understand me?
Yes.
Move forward.
Mr. Carlock, I think in the prior proceeding, you had stated that the property was livable. Are you still saying that the property is livable today?
Am I saying that the property is livable today?
Yeah, your prior statement in the last proceeding, October 31st, you stated the property was not livable. Is that correct?
You're asking me my opinion of the livable property. I do not see how individuals can live in a property with no utilities, no running water. And the evidence that I've seen is looks like there's been some illegal work, plumbing done, and it's been just destroyed. There's holes in the walls, there's rats coming and going. So if you're asking me based off of that, in my opinion, do I think that's livable? I do not think that that's a livable property based off what I've seen. I don't know.
So did you see the evidence that I presented before? Did you see how the house was, my mother's house was when you was executor unlawfully, and we took video going through the house and how it was ransacked? So you saying that's how Teresa Carlock property should have been done like that, right?
I was physically inside the property December of 2020 2022. Actually, I went to visit Mr. Mason on my way back from Oklahoma City just to see how the house was doing. Which he had several pet bulls. Right, actually got bit by one of the pet bulls. But at that time, I didn't see that the damage that I seen in the recent videos when Miss Thibodeau, Janelle, went to the property. I didn't see holes in the wall. I didn't see red and blue pipe water lines exposed. I didn't see the huge holes, literally from the outside to the inside. The walls are missing where rats and animals are able to enter and exit. So no, I didn't see that. The last time I went to visit Perry myself to see how the house was going, he gave me a tour. Said, "Hey, this is the work we're doing." This was prior to the 1 year mark when he was still working on his credit. Gave me an open tour. The house was not outside, the dogs running in and out. There was not a lot of damage, but what I seen on the videos from March of 2023, it is unlivable. It has been destroyed by somebody.
Mr.
Okay,
Carlock, hang on. Mr. Carlock, in your answer, you said you were there December of 2022. Are you talking about December of 2021?
2021, Your Honor, I'm sorry. December of 2021, because it was still before the 1 year mark of the time he had for the credit. Yes, December of 2021.
Thank you. Next question.
yeah, I have video evidence showing him being there prior to that, showing the condition of the estate.
Prior to what?
Prior to December 2021, when he stated. he
No,
was
that wasn't
there.
no, hang on. That wasn't your question. When was the last time? If he was there prior to it, it doesn't matter. You asked Mr. Carlock when he was there the last time. And he said December of 2022, which he was mistaken. It was December of 2021. If you had
Okay.
evidence of prior times, ask him about it. But all you asked was the last time.
Okay, prior to that, you don't remember the being at the house and me and Perry came there and you was forcing Perry to go in the house and we took video at that time and you tried to get me barred. You had Sandra on the phone at that time. Remember that incident? That's prior to December 2021, sir.
Yeah, no.
You had
Yeah,
police?
the last time I was there was December 2021.
Okay, so you don't remember prior to that when you called the police over to 1704 North Beverly Drive and I was there, me and Perry was there, and you tried to get get me barred. Perry was supposed to be getting refrigerator out of there. You remember that?
What time frame are we talking, Mr. Mason?
We're talking about probably about April of 2021 when you
So-
came down with your wife and your children and then started to convince you to call the police. You had the police already on the property.
Hang
So
on,
if I-
hang on. That was prior to him being appointed as independent executor. Is that correct?
Yes, sir. Yes, sir.
That has no bearing on this hearing. This hearing is to determine if Mr. Mason should be removed from the property if he still occupies the property. I do not care about what happened between y'all beforehand. Honestly, don't care about what happened between y'all afterwards. The only thing I care about is Mr. Carlock as independent executor, as named by Ms. Carlock in the will, is taking control of the estate property. That's it. Next question.
So I can't be any rules and violations that he's did during this time? I mean,
He
that's all I
was an
ask.
independent executor at that time. We heard this last time. You had an opportunity to present with evidence last time when he was named independent executor. This is only about whether Mr. Mason, Perry Mason, is occupying the property and if he should be removed from the property. That's it.
Okay, so we're gonna bypass the lien I got on the property. We didn't complete the work, sir, because it's this same madness they brought to his attention. Okay.
You haven't brought anything up with it in regard to any lien, nothing along those lines. This is solely about Mr. Carlock taking control of estate property. That's it. Until it passes to the heirs, it is not the heirs' property. It is the estate's property.
So the executor of the estate is his property now, as you just telling me now? The
It's
executor?
the estate's.
Estate's property. Okay, so therefore you.
The estate takes in the property. The independent executor takes in the estate property. He then disposes of the estate property by the will. That's it. That's where we're at. Mr. Carlock is attempting to take control of the estate's property, which is the residence in Wichita County. Mr. Carlock was also awarded the power to sell by the will. And once those proceeds are gathered, it will be divided as per the will. It's not a tough ballgame.
So police violations and none of that have anything to do with this case? Taking
You're-
property out? It's
you
not
haven't-
the estate property, it's Perry's, it's his personal property in the house.
Are you representing Perry Mason?
No, sir, he's trying to
Yeah,
get on, but he
Need
can't
to
get
move
on.
on. Then you need to move on.
Okay, I need to move on. I can't keep trying to get on, brother, because I can't say anything to you right now. Okay,
If Mr. Perry Mason has a claim against the estate, he can raise it.
well, he can't get on video because if he kept trying, he can't get on. And he's the main witness. I know, and he's on the road. Okay. All right.
He hasn't filed anything. You are the only individual in this matter that has filed anything. Again, I'll ask you, are you representing Perry Mason?
No, sir, I'm representing my
You
mother's
need to
estate.
move on. Then you need to move on.
Okay, all right. I noticed, President Carlock, that in the last proceedings, you mentioned that there was only, we mentioned $67,000. But I see that the executor, the guarantee title, got the paper on your listed inventory, showing $90,000. Did my mother know about that money, $90,000?
Objection, this has nothing to do with the house and is irrelevant for this proceeding.
Sustained. Move on.
Okay, that's just. I was questioning his list and inventories of the estate. He just at random valued everything of a big value off the top of his head, especially like for the Buick. He was 2,000.
Objection again, Your Honor. He's talking about values of
Okay.
property that are not involving this matter.
The value of the house,
Irrelevant.
the value of the house is at issue in this. The only thing that is at issue, I will say this one more time and I'm about done. is, should Mr. Mason be removed from the property if he is still even inhabiting the property? That's it. If you have a question relating to that, get after it. If not, then you need to pass the witness.
So the only reason you want Perry Mason out the house is totally just to sell the house, correct?
Correct.
And you're gonna divvy up the amount of money 5 ways, correct?
That's the will. The will,
Okay.
yes, we're gonna go by the will, what the will says, correct?
So is $51,000 substantial for that house? I mean, heck, there's be a lot of people out there, you know, that's about that house at that price. Why would you quit that figure?
I think this is irrelevant, but I'll answer your question. The house has got severe damage. We're talking holes in walls. We're talking the plumbing is pulled out of the walls. I've already talked to a realtor before. The roof is not going to pass inspection. And you're dealing, you got back taxes. You're dealing, and based on my I'm not a realtor, but based on my personal experiences from buying and selling homes, that is really, we're glad to get somebody to at least buy the house. Because if you go through one of those places like We Buy Houses and things of that nature, the purchase was way less. So Mr. Lawrence has made, in my opinion, a great offer based off the condition of the home. The home is a wreck. So if to answer your question, I think we're doing really well. Because it's not going to pass an inspection if we put it on the market. It will not pass inspection. Mr. Mason has a VA loan from his time in service. I use VA loans. I understand the inspection level of a VA loan. That house will not pass. Guaranteed will not pass for a VA loan.
You mentioned just a minute ago, past taxes. Wouldn't that be sufficient to say that as executor that you did not pay the past taxes on that home of $3,212? Would that be sufficient to say?
Mr. Mason said as part of him occupying the home that he would pay the tax.
These are taxes that was due payment at the time of Carlock's death.
Mr.
So
Mason
as
paid.
executor, you was responsible for these taxes, sir. Is that correct?
Mr. Mason paid the taxes to move into the house. He said he was going to continue to pay those taxes as being a resident, not paying rent, not paying anything. And he has not paid the taxes that are past due.
Right, but these are past taxes, as you say. Perry Mason paid the taxes in 2021, which was $1,080.
The taxes were caught up at that point. I'm talking about just the recent, the 3,200 that's due right now.
These are past taxes, sir, because the taxes 2021 were paid. Mama paid her taxes in 2020. So it's got to be 1 year is not going to, if it's $1,083 per year. That's sufficient to say it's past taxes. You said past taxes. Did you say, sir?
There are taxes owed on the house that Mr. Mason has not paid.
So as executor, you felt you weren't responsible to pay them taxes?
Mr. Mason agreed to pay the taxes upon his agreement to move in the house and to get his credit built up.
So you got to sell the house to pay the taxes? And this, as executive, these taxes should have been paid, sir. Isn't that correct?
Again, Mr. Mason said he's going to pay the taxes as part of moving into the house.
And it shows here, Perry Mason paying the taxes 2021, $1,083, $1,083. But these taxes is
so the amount you're stating, the 1,000. So that was based off of, you got to understand, our mother was elderly, so she got a discount. The taxes are not that amount anymore after she deceased. The 3,200 is the new amount because the 1,000 amount, that's a discount she gets for being elderly, over 65. So what's owed now is from the time Mr. Perry Mason has lived in the house.
Now, you mentioned, you said it correctly, that Homestead Act, once she passes, all the taxes that she wasn't will come upon the.
My mother was not behind. She was not behind on any taxes.
Exactly, but once she passed, the homestead don't go into effect, sir. And so therefore, the back taxes was the responsibility of the executive. Yes or no?
Again, as an agreement for no, because the house is in 5 names. I was not the executor at that time, as your honor has already stated. So no, your answer
But
is wrong.
these taxes haven't changed, sir. You was executive November 2023 or 22, and these taxes were still the same.
Mhm.
So you didn't feel as executive you should pay?
No, and absolutely not, because Mr. Mason said he's paying the taxes as being a resident of the home. So one of the things we're going to do with the sale of the home is pay those taxes.
If you made a verbal agreement saying if he paid the taxes on the home, he could stay in the home, why are you backing off the agreement? He's
He
going to
hasn't
continue
paid.
the taxes.
has,
He
number
paid the
one-
taxes last year. This is 23, paid 22, 2022 taxes.
Objection, Your Honor, he's not even letting the witness answer the questions that he's asking.
Let me get to the bottom of this, please. This is taking forever. Have the taxes been paid for the tax year 2022?
No, sir.
No, they have not.
And that's when Mr. Mason was allegedly living there, correct?
That is
Mason
correct,
been in
Your
that
Honor.
property since 2021, sir.
The 2021 taxes are paid.
2021, yes, sir.
Great. The 2022s are not.
Yes, sir.
And the independent executor had made an agreement with one of the heirs, beneficiaries, legacies, whatever you want to say, that he could live rent-free in a home of the estates so long as he paid the taxes, correct?
Correct. And he's
And those
gonna pay the
taxes, hang on. And those taxes for that time period have not been paid. Is that also correct?
No, sir. He paid the taxes since he been there. He says he's been proud. He paid the taxes. This
So
is
you're, so wait a minute. So hang on, Mr. Mason. So you're telling me that since January of 2022, that Mr. Perry Mason has not occupied the property?
No, he didn't occupy the property. January 2022,
January of 2022 on, he has not occupied the property, correct?
Perry was in that property. Yeah, he was occupying that property with his personal belongings. He was in that property, yes.
Good. So then he should have paid the taxes as per the agreement with the executor, correct?
And he made it, he's making all intent to do so. He told me
I
that.
don't want to hear
himself.
about, no. I don't want to hear about all attempts.
Okay, no problem. I'm sorry, sir. Okay, I can't get him. He's still trying, but I can't get him on here as a witness.
You need to move on, and you're
Okay.
dangerously close to Barratry. And I will promise that the record will be sent to an individual who can look into it if you persist.
Yes, sir. I'm sorry, sir. Okay, I'll pass the witness on you.
Mr. Rayfuse, any further questions for this witness?
Yes, Mr. Carlock, were there any funds in the estate that could have paid the taxes prior to today?
Any funds in the estate from the time of my mother's passing?
Right.
There were, yes, she had funds after her initial passing that were in a joint account with Miss Sandra C.
And was Sandra the joint tenant with the right of survivorship?
Yes, she was.
So after that account was disposed of, were there any other assets that you could have used to pay the taxes owed by the estate for 2022?
No, all the assets had been removed from the home. No, there was nothing else to use as far as the house and assets to use to pay the taxes for 2022.
And there are some debts of the estate, and your plan is to pay those debts before distributing the proceeds from the sale of the house. Is that right?
Correct. I'd like to sell the house and pay any debt that the house has acquired, taxes or whatever else. And then after that debt's paid, and then the rest of the proceeds will go to the 5 individuals listed in the will.
That's all I have for this witness. I'll pass the
Nothing further,
witness.
Mr. Mason?
I don't have any questions, sir.
Next witness, Mr. Rayfuse.
Movement would call Janelle Thibodeau.
Ms. Thibodeau, can you raise your right hand for me and unmute yourself?
Yeah,
Ms. Thibodeau, do you solemnly swear or affirm testimony you give in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you. Go right ahead, Mr. Rayfield.
Okay, Ms. Thibodeau, there's a little bit of a delay. Can you hear me okay?
Yes, I can hear you. A little bit,
Yeah, it's-
get it afterwards. Okay, now it froze.
okay, that's better. Can you hear me okay now?
Now I can hear you, but you froze a minute ago.
Okay. Well, did you have an opportunity over the weekend to review movements exhibits 2 through 4 video recordings of the house of your mother?
Yes.
And were you present when those videos were made?
It was in March of 2023.
You were present when the video was made? You were there in the
Yeah, I was
house?
there.
And did those videos accurately reflect what you
Well,
saw with your own eye?
my dad took the video.
Well,
Okay, he's breaking up. I didn't get what he was saying.
let's do this. Hang on a second. Ms. Thibodeau, why don't you disconnect and try to reconnect? Your connection has gone bad. We'll go off the record while you do that.
they trying to get me, yeah, I can't say nothing about you, but you're not being there as a witness, I can't say nothing about you. I can't get you up here for nothing. I know that, and he trying to put me in jail, dude. Yeah. I can't say nothing about none of that. I mean, I've been trying it, and this judge is smashing. You're not representing, I'm representing the state of Teresa Carlock, but I represent you. They trying to get me thrown in jail saying I represent, I'm not representing you, but I can't, y'all, the man ain't received none of that, man. And I can't get him on the daggone deal. So it's like it's gonna be a slam dunk on me. I'm at to ask for at least 30 days. You gotta have some time to come get your stuff, man, get your stuff out too. You know what I'm saying? They just can't come in there and just, they gotta give you some time to get your stuff out, man. Dang, if they can't prove you received any of those things, man, they can't prove none of that. You know, none of that. They can't prove none of that. Yeah. They threatened to get me arrested, man. I ain't representing them. I know I can't represent nobody. I'm representing my mama's estate. I mean, but like when I put that paper in, I had no way to contact Janelle. I was supposed to subpoena Janelle Thibodeau. I was supposed to subpoena Janelle. They had nothing. No, I didn't know that, man. I saw, so I got to do it. I do it, but I didn't know it. So now everything I brought to court is going to be, can't be heard. Can't be heard. I know it. I told him that you can't get in. So. Yeah, definitely get in. I'd have to take off some of them daggone apps just for it to do it, You ever thought of that? I gotta do something. Limited up.
Mr. Rayfuse, Mr. Carlock. It appears Ms. Thibodeau is back in. Let's get this hearing concluded.
Okay. Ms. Thibodeau, could you turn your camera back on?
You too, Mr. Rayfuse. I need your camera, Mr. Carlock. There we go. Progress.
Janelle? Oh, we lost her.
It's her connection.
Hmm.
Let's go on the record. While we were on this little break, Mr. Mason, you were not muted. You do not represent the estate. Mr. Mason, if you purport to represent the estate, that means you are representing individuals other than yourself. In probate matters in the state of Texas, you can only represent yourself.
Yes, sir.
Not the estate,
Wrong choice of words, sir.
not other beneficiaries. I know, and that's what we've talked about before. Those are terms of art. And when you use them and you use them incorrectly, it can end up biting you in the rear.
Yes, sir. Yes, sir.
We'll give her a little bit longer.
Let's see if I can find out what's going on.
All right. I'll be back when she pops in.
Judge Janelle says she's in the waiting room. Do you see anybody in the waiting room?
Mm-hmm.
All right, Ms. Thibodeau, just need your video.
Turn your video back on. Oh, I thought she was there.
She is there. She's on mute and also doesn't have a video turned on.
For my debut.
Gonna try a different device.
Okay.
Keep going, it'll pull up. Should be able to get on there. You moved in the house 2021. Yeah.
All right. Can you hear us, Ms. Thibodeau? Are you there?
Can you hear me okay? Am I still muted?
Is your mic on?
There you go.
There you go.
All right. Mr. Rayfuse, go right ahead.
Thank you, Your Honor. Janelle, I'm gonna kind of ask the same questions again because I'm not sure you heard everything. But were
Okay.
you present when the videos, which are movements exhibit 2 through 4, were recorded?
Yes.
And who recorded those videos?
My granddaughter.
And did you watch those videos this weekend?
Yes.
And do those videos accurately reflect what you saw with your own eye when you walked through the house?
Yes.
Your Honor, I move to admit movements exhibits 2 through 4, video portion only, no audio.
Mr. Mason, have you seen the videos that Mr. Rayfuse is offering?
Yes, sir, I have.
Any objection to the video portions, not the audio?
Uh, The video itself, sir, shows the remnants of the work that was being done in the house. So I would object to that video because I left the walls open, putting that plumbing in, and at the time we didn't continue because the period, felt like he didn't need to spend no more money because they were talking about selling the house. That's the reason the walls are in the house, all that can be closed up. I would object because it's showing the condition that I left it in when I did the work.
Okay, so it's accurate. So the videos themselves are accurate, though. That's the way the house looks.
That's how,
Yes.
but yes, it's, the rat infestation he lives in a field. Everybody on that block got, even Boys Club got rats, so.
I'm not worried about that. What I'm asking about is the videos. Do they accurately depict the house the way it is?
When they went into the house, sir, yes, the TV that is stolen now, it shows the TV in the house.
Not asking,
Okay,
I'm not asking about, I'm just, the
Yeah,
condition of the home, is it accurately depicted in the videos?
as far as in the bathroom with the holes, the walls left open under the kitchen sink, wall left over in the
Whatever.
bathroom wall. Yes, sir.
Okay,
Other than that other condition, no, that wasn't the condition of the house in period. That's it. So-
no, I'm not talking about that. I'm, as it is, that's accurate at the time of the videos were made.
Okay, yes, sir.
All right, and then the objections overruled, videos are admitted without the audio portion. Go ahead, Mr. Ray.
Hey, Janelle, while you were in the house, did you remove any personal property belonging to Perry Mason?
No,
Did you see any property of the estate inside the house?
no,
And this recording was made in March of 2023.
yes.
At the time that you went into the house, what was your understanding concerning the occupancy of the house?
It was horrible. I've never seen my mom's house open up like that. And I don't see anybody living in it like that. The toilets had no water. There was no lights. Yes, rats mess all over the floor.
That's all I have. I'll pass the witness.
Questions for the witness, Mr. Mason?
You stated a while ago that no property was stolen from the house. Is that correct?
Correct.
No, Your Honor,
Prior to-
actually, that's not the question and the answer that was given.
Question, the answer that was given is no property of the estate was taken from the house. Period. That was it.
And when I went to the house, 2 days after that, well, prior to that date of the 25th, about the 21st, I have a police report showing, well, I can't show that neither. Okay, so if you wouldn't know, property taken from the house, how did the vehicles, come up missing from the house?
The vehicles were not missing. Okay. We were in the process of thinking we were selling the house to We Buy Houses, and they did not want all that trash on the property.
So you saying that you removed the Buick and the pickup truck from the
The
property?
pickup truck been there for years, and Mom wanted it removed, but Michael never went to do that. But anyway, yeah, I had the cars towed and to a shop to see if they would even run.
Did
Perry
Michael Mason-
really did. Excuse me?
Did Michael Mason give you the authorization to remove his truck?
Is Michael Mason here? Yes, he did. He didn't say anything. He just knew the truck should have been removed because we're trying to sell it. He wanted his portion of the money. So yeah,
Well, you know, Michael Mason made a police report too of a stolen vehicle. Are you aware of
that's
that?
sure, y'all can do what you want to do.
You're aware that
But
Helen Mason-
how you gonna make a missing property when it's back? Y'all wouldn't put it back on the property.
All right, I'm gonna tell y'all one more time. This is not Family Feud. I'm not.
No, it's not.
Ma'am, you're just as bad. I'm not gonna
Yeah.
listen to this stuff. The only thing I want to hear about is the house. And if Mr. Mason, Perry Mason, should be removed from the house. So
Yes,
it
he should.
so, ma'am. The only questions that are relevant are with regard to the occupancy of the house. I'm not going to talk, I don't want to hear about automobiles or anything along those lines unless they are that of Perry Mason.
Yes, sir. The property in the house, Your Honor, was all the property is in his house. Yes, sir.
Next question.
Mr. Mason and his wife had a credit card taken from that mailbox prior to that, and there's been several incidents at that property, sir.
Objection,
Yeah,
Your Honor. This has nothing to do with the house.
No, it does have to do with the house, but it's not a question.
Well,
This is your opportunity to ask questions of Ms. Thibodeau. If you want to testify here in a little while and subject yourself to cross-examination by Mr. Rayfuse, that'll be your choice. But right now, the only thing you have to do is ask Ms. Thibodeau relevant questions.
So you did have the vehicle, the truck, and the vehicle removed from the property. Ms. Thibodeau,
objection. The question has already been asked. It's already been answered, and the court's already ruled on its relevance.
She answered that yes, she had the pickup truck and the other automobile removed from the property to a shop to see if they run. Next question.
the property, she moved it from the property to a shop, and the guy was ready to buy the property. So what I'm asking is, isn't it in the will of Teresa Carlock Davis that vehicle belonged to Perry Mason?
The house was abandoned. And I thought Perry left everything there. The only thing missing from the house was mom's stuff. That's it.
Are you aware that that car belonged to Perry Mason?
Wait a minute. That assumes facts not in evidence. What is the
Yeah.
car? Wait, no, you listen to me. Whose name is the car titled in?
Oh, it's Teresa Carlock Davis.
Yeah, so what does that make that car? Have we learned anything today? That makes that car property of the estate for the independent executor to take control of and then dispose of as the will states. Now,
Okay.
move on. We're only talking about Mr. Mason being removed from the house. I'm dead serious. I'm going to put up with this about 2 more seconds.
Your Honor, I'm gonna pass this. I'm not gonna. I didn't come in here prepared for this. I came prepared for mine, and I'm not going to jail, sir. I don't want to go to jail. I don't want to say the wrong thing.
I don't want anybody to go to jail either. All I want is the assets of the estate to be gathered as quickly as possible and be distributed to the heirs as quickly as possible. So we don't have to do this again.
Okay. The property that's in the estate right now don't belong to the estate, sir. So it belongs to the other beneficiary. I think he needs some time to get all his property out that estate. I would ask the court first.
Okay, wait a minute. So what you're saying is Mr. Mason has some personal property in the home that he would like to remove. Is that what you're saying?
House full of furniture.
Understood. Understood. So now, Mr. Rayfuse, Mr. Mason has passed Ms. Thibodeau as a witness. I assume you don't have any more questions for Ms. Thibodeau.
No, Your Honor. And I have just a few brief matters to testify on my own to clarify some of the issues.
Do you solemnly swear or affirm testimony you give in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go right ahead.
My name is Robert Rayfuse. I represent the executor who is a movement in this motion for show cause order to vacate real property. In November of 2022, after Mr. Carlock was appointed as the executor, I sent emails to Perry Mason asking him if he wanted to buy the house, and if he did, to contact me to make arrangements. And he did not respond to those emails. I later sent a 30-day notice of termination of the lease, which is Movements Exhibit 1. This is a true and correct copy of that letter, which was sent both certified mail and regular mail. In my office, I received neither return mail of the certified or the regular mail, so I have to presume that it was delivered at some point to Mr. Carlock or Mr. Mason. And in Movements Exhibit 1, I specifically mentioned we need to move on because he hasn't contacted me concerning the option to purchase the house and that he hadn't paid the 2022 taxes. And I never received any response from Perry Mason, either by phone call or email after I sent that letter. That's all I have. I'll pass the witness.
Any questions for the witness, Mr. Mason?
Yes, sir. If I got my brother in my ear, you know, I will go by there and pick up the mail. And we had problems at that mailbox on 1704 North Beverly. You got a school down the street and the boys club next door. Mail come up missing all the time. Matter of fact, I got a police report stating in March that a card sent to Perry and his wife, which is a tax card for his taxes, was taken, and that same day they spent it at Walmart. It's a police report on this, and it's under investigation. So to say that you put it in a mailbox and say that it's in the mailbox, all I can say is that that mailbox has problems. My mom never used that mailbox. She had a box downtown, post office box. So any documentation that needs to be done, she get it to the post office box. Any documentation that gonna go to that mailbox without them kids coming through, sir.
I asked about questions for Mr. Rayfuse, not testimony. If you have questions for Mr. Rayfuse, that would be great.
Mr. Refuse, are you aware at 1704 North Beverly Drive that there was that mail is being taken out of that box?
No, I was not.
Okay, and there's an incident, a police report just dated just this 3/16 of a theft of a credit card out the mailbox. And the police, we had that report. So that was probably way before you sent, prior, after you sent your stuff. So to say that it was sent and we got a theft of property out of the mailbox from somebody, the police haven't come up with who it is yet. Then that wouldn't make that mailbox secure, would you say, sir?
I have no idea about the security of the mailbox. I just put the letter in the mail through the United States Postal Service.
Yeah. So no, I need my brother to just get in on this because I can't go any further on that questioning, sir. Or I implement myself as being one to representing and someone I'm not trying to represent, sir. So I'm through questioning his.
All right, thank you.
I
Anything
have
further?
nothing further, Your Honor. I'll pass the witness, and if the court doesn't have any questions for me, the movement will rest.
I have no questions. Mr. Mason, do you wish to testify or offer any evidence with regard to the house?
I'd like to testify in regard to evidence as far as the police report is concerned, sir, as theft of property and burglary as a habitation because they got a gun being missing out of that home, jewelry, silver coins, and a big screen TV that was on their evidence when they submitted to the court. I saw that as well. So I do have a police report, sir. Could I submit that as evidence as one to take questions as a witness?
Objection, Your Honor. It was not presented timely as an exhibit for a Zoom hearing.
As evidence of what? I mean, your contention is that Perry Mason is still in the home, correct?
Yes. Could I get a continuous? Because he's still living in the home. You know what I'm saying? He's been living in the home since he paid the taxes and been on the road. I can understand that, but this is all I got, Your Honor. The stuff that went out, the truck wasn't on the estate. The TV is not part of the estate. The gun's not part of the estate. The silver coin's not part of the estate.
And Ms. Thibodeau and Mr. Carlock both testified that they didn't remove those items.
Yes, sir, they sure did. There's a police report on that, that those items have been missing. And
I
Perry,
understand,
he
I
get-
understand the items are missing. I understand that's your contention is the items are missing. However, Mr. Carlock and Ms. Thibodeau just testified under oath that they did not remove items other than
Okay.
what Ms. Thibodeau testified to was about the vehicles. That's it.
Well,
Now-
the other item that was
Again,
removed was the
hang
chicken
on,
coop.
I'm just indulging you with regard to what you're asking. This
Yes,
doesn't
sir.
have any bearing on whether Mr. Mason, Perry Mason, should be removed from the residence so the estate can collect the estate assets and sell it for the benefit of the beneficiaries and heirs. That's it.
Well, I got Perry Mason in his ear. He's trying to get on there. He wanted to know if he could reschedule, sir, because he can't. be
No, he
here.
cannot reschedule. This Zoom was made to accommodate all the parties. Mr. Mason was well aware that this would be by Zoom, and he had told the court's administrator that he would be on the road, but it was better because then he could participate because it was by Zoom. That's why we did it this way, so everybody would have a fair shake. So now, if you could testify with something with regard to the home, that's up to you. If you observed it, great, that I'll hear you. You'll be subject to cross-examination by Mr. Rayfuse. But other than that, we're not getting into the family feud stuff. We're not getting into these past transgressions that you believe have been committed by Mr. Carlock, Ms. Thibodeau, or anybody else. Mr. Carlock was appointed as independent executor with the power to collect and sell property as given by the will. So I want to hear about the house and whether Mr. Mason should be removed at some point and take his belongings with him so the house can be sold. That's it. What do you have with regard to that, if you would like to testify?
Is my lien irrelevant? And because I can't testify for somebody else. I can only testify to what I did to the house to get it livable. For Perry Mason.
You can testify to whatever you did with regard to the house. That's fine. You can testify to what you've seen with regard to the house as it exists today. You can testify whether it's your belief or understanding if Mr. Mason still occupies the house, even though it has no running water or utilities.
I'll testify then.
Raise your right hand. Do you solemnly swear or affirm testimony you give in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Go right ahead.
Your Honor, my brother been in that house over a year. And there wasn't no water in that house at the beginning. I got pictures to show the work I did, the plumbing underneath the house and everything. I brought pictures of it. And so I did present that to the court in the last hearing. I guess that wasn't what we were hearing about as far as my lien. I put that lien on the house because I felt that they would want to sell it. They wanted me to fix it and they wanted to turn around and sell it. I did the work on the house. I got the proof. I got the everything in there on that house, and I did the work. But as far as the property of that house, they said that it belonged to the estate. There was property that was taken and what didn't belong to the estate. So like my property, I had a chicken coop over there, and why would they take a chicken coop? I had two igloo dog houses over there. Why would they take the two igloo dog? They're not going to admit to it, but they're the only ones been on that property since. And as far as
that's not necessarily correct, because you just stated that there's a police report that somebody stole something just even out of the mailbox.
Right, here it is. I got it right here. That's before I found that the vehicles was taken. Here is the mail theft, sir. Is dated 3/1/23. Mail theft. Perry Mason, wife Hillens, because they was and Perry Mason both made this report. Stolen out the mailbox.
Now, Mr. Mason, what I'm getting at is there are stuff's going on at that residence. Is that correct?
Well, prior to that, no, I mean, because nobody had no mail going to that box. Period, didn't even have no mail going there. It was an accident that the bank made, sending it to that address instead of to where his wife is with next to, they down there in next to her mother, his wife's mother's sick.
You
She
said it
down
was
there
a
to,
tax refund card?
it was a bank card sent to that daggum mailbox. It's supposed to went down to the valley. They sent it to 1704. They were spending the money. He spent the money the same day that people were spending money at Walmart.
Okay,
This
and with Mr. Mason, was either of those people Miss Thibodeau or Mr. Carlock?
Well, sir, there's they don't know who the suspect is. Officer Levick and Officer Glenwell Carroll, they took the report, American Express cards stolen.
Mr. Mason, you also said that the card should have gone to somewhere else. Where should it have gone to?
Well, Perry's wife, Perry is income tax money. Perry's wife is living in the valley because Perry's wife is sick. As you know, everybody want to get by his mother. So Perry had to move his family down there to be with the mothers. The son's down there working and everything. Helen's taking care of her mother. So Perry's still at this residence, but they supposed to send these cards down to that. They had called the bank and everything, and then they sent it here the same day they sent it. Somebody was in the mailbox.
All right, go on. Let's move on.
Man, got it, okay. Also at that time, after that, that's when the two vehicles were reported. Also, the chicken coop was reported on that, the two dog houses that's here and here, and theft, and the bill, and that's the other document talking about what was in the house. So when they made entry to the house, you saw the TV in their video. When Perry come in the house, the TV gone. And they had to take their time to take that loose. They may not say they did it, but they were the only ones to gain entry into that house. A 380 gun is missing, and it's on this police report. Some silver coins is missing, and some jewelry. Only ones that enter to that house is those that's on defense now. So
Okay.
my understanding is this right? I just want to be just, he got his Social Security is in his house. So how they get to be able to cash his card? You had to have a Social Security. They even changed the email to another email because he's talking to the people. So these people, whoever did this, is very strange. And all of a sudden they come with all this other documentation saying get out the house. So that's all I got, Your Honor. My brother's not here to testify for himself. I don't want to go to jail trying to do nothing on his behalf. I'm only on behalf of my mother. She's dead. And that's the only one I can stand up for is my mother, no one else. And I put in a subpoena for the courts to give me information from Wells Fargo, and I haven't received that. And I'm pretty sure that bank gonna have a statement saying that Teresa Carlock Davis was not aware of that account that they claimed ownership of.
I'm aware of what you put in. I'm aware of what you put in, and that is not how you get those documents.
Okay, my bad again, sir. All I'm doing is a desperate act. That's all I'm doing is a desperate act. That's all I'm saying.
I can't do anything about a subpoena that it didn't follow procedure. Two, it's not the right avenue to receive those documents. I mean, you don't understand what you're doing, and we talked about this last time. Okay. And I cannot give you legal advice. Mr. Rayfuse, do you have any questions for the witness?
Mr. Mason, you said that Perry had moved his family somewhere so that his wife could be with her mother.
It was an emergency. Him and his wife, his boys are already gone. They had already made their decision way before they wanted to move, but it was an emergency. His mother got real sick, and they went down there only with just a few things. You know, the furniture stuff still in the house. He brought her, to make his wife comfortable. He had to get everything down there. Only thing he took out the house was a bedroom TV. So
When was that move? Do you remember the date?
The date of that move, it must have been, what is this? It was recently, probably about the end of last year. When'd you move down there, Perry? Help me out.
No, it didn't work that way.
I don't know.
If you don't remember, that's okay. I was just
All right, you know, I don't
wondering if
remember.
it coincided with the time that the water was turned off.
Well, the water was turned off. So water was turned off because he came down to check on the house and he had got a bill and we put a plumber, not outside faucet on the side. Somebody had cut it on and left the water on with I don't know how long. And so he couldn't pay the bill. And you know, somebody been watching that house and somebody been doing some sabotage. So that's why the water bill went off because somebody cut it on the side of the house. Who, we don't know. And so that went off and the electric stayed on until, you know, everybody hit tough times. And my brothers had some tough times and he had to, this reason he got the electricity back on. So that was the reason the water was off.
So to your knowledge, has your brother or his wife contacted GM concerning the Cadillac that's sitting in the garage?
As of today, that vehicle been gone. You know, GM was all he was waiting on the time Perry got off the road to come get the car. Perry came down the same time. Perry came down, got that vehicle out of there. That was right before we had that last court proceedings, I think that was. And that car been gone. So
Yeah, the Cadillac was in the garage in March of 2023, right?
yeah, right. This last proceedings we had, June the 3rd and June the 5th. That's when that car was gone, way before that. June 3rd, June the 5th, Perry come down there at court. We had that car gone out of there. They came and got it.
Are you talking about the April hearing?
I'm talking that. Yeah, I'm talking about the hearing they had in Judge Hughes' court.
Okay, that was in April this year.
Right. Yeah, that Judge Jim came and got their bill with him.
That's all I have. I'll pass a witness.
All right, anything else?
Your Honor, I'm sorry I didn't go through the proceedings of getting the whatever, but I did have evidence that could substantiate removing him from the executor, and I can't use in this proceeding.
All you have to do is serve the appropriate person and then schedule the hearing. We'll hear it.
Okay, I'll do that, sir. I sure will. Would it be all right just to email her? Because I don't have no address or nothing.
You have to look at the code and follow the rules. If you're going to represent yourself, you're going to be held to the same standard as an attorney. You know that.
You know, I went down this whole week trying to get that book, and this law librarian told me some judge had it out the whole week.
I've got my own copy, so it's not me.
Well, I'm glad to hear that, but somebody had it, so okay. I'll go back down there and look into it. So, all right. Can we have at least some kind of way of having time for this, another proceeding until you finalize this thing? Can I have a chance?
I'm going to rule on Mr. Rayfuse's motion today. You can present your motion at a later date once you follow the proper procedure on getting the proper individual served with your motion. Okay? Anything further, Mr. Rayfuse?
No, Your Honor.
Great. Court finds that the property of the estate that was previously inhabited by Mr. Mason under an agreement with the independent executor is now abandoned. The court also finds that it would be in the best interest of the estate for that property to be sold and the proceeds to be divided after all debts and liens or valid liens with regard to the property are taken care of. Just as an abundance of caution, the proceeds from the sale, once it is done, will be put into the registry of the court or into an estate account that Mr. Rayfuse controls. And then we will deal with the distribution later, as I'm sure there will be some issue arise with regard to who gets how much. Mr. Perry Mason will be given until 5 o'clock on the 31st of May to remove any personal belongings that he may have in the home. Mr. Rayfuse, if you're looking at the videos, there's no estate property of any value in the homes. Is that correct? In the home?
Correct.
Right. So we can assume that any property that is left there is the personal property of Mr. Mason or his family, and he is entitled to that property and can have it removed by May 31st at 5 p.m. That'll be the order of the court. Yes, Mr. Mason?
Well, my brother wasn't, I've got him on the phone, so I'm gonna relay this to him to let him know he got to May 31st at 5 p.m. you say?
That's what I said.
All right, okay then, so that's when he gotta remove his property.
That's correct. Anything further?
Well, as long as they can't come on that property and start chunking everything on the computer is on the road, sir. And I got my own home. I got to go over there and keep checking it to make sure ain't nobody on that property. I got my lawnmower. We cut the lawn grass over there. He got his lawnmower. I got my weed eater. I got my trailer over there. I don't want nobody to come over there and start taking off the property when I got to get over to get my stuff. I had to cut my yard.
You've got till May 31st. After May 31st, it gets disposed of.
All right, okay. Well, before then, they're not gonna do anything, correct? I mean, I don't trust them people. I mean, they come in there and did what they did with police reports, and I can't get no recourse, no redress, no grievances accepted on a criminal act. I'm stuck like Chucky.
No proof.
I got police reports. I don't know who did it.
There you
I
go.
mean,
That's what I'm getting at. You don't know
I
who did it.
don't know who did it. Yes, sir. Okay.
That's all. We're done. Thank you, Mr.
Thank you,
Rayfuse.
Judge.
Order.